Today I will be discussing the restitution of church property in Hungary. So allow me to start by looking at the historical background that shaped this process. All right, before 1945, the church was not just a spiritual guide. We heard that already. It used to own substantial land, buildings, and of course other assets. For example, in the 1920s, around 24% of the nation's land belonged to religious institutions, or for example, more than half of the schools or educational institutions were run by churches. So we can state that churches played an important role in societal life and could be characterized by power, great wealth, and of course, with this wealth came great influence. Now, how did this shift? Communist takeover after the Second World War, of course. Radical changes were brought, and Hungary fell under the Soviet sphere of influence. And we can say that as part of a very complex ideological, political, economic, and historical influenced interplay of factors, on which I don't really have the time to elaborate, but I think that there is no need to elaborate on these things. So as part of this broader strategy, almost all church property was confiscated under nationalization measures. Just to exemplify this harsh approach towards ecclesiastical property, for example, in 1945, the land reform influenced church property. However, this wasn't the truly anti-clerical nationalization process. So that started only in 1948. But from 1948, the Act number 33 led to the nationalization of churches, schools, student residences, kindergartens, and neither de jure and nor de facto compensation was offered, but also foundations were dissolved. One legislative decree mandated the dissolution of religious orders, another one led to the nationalization of church-owned service apartments, office spaces, and so on and so on. So all these examples revere the primary goal of the communist church policy, that was the eradication of religion and disabling the churches from their educational and social functions. This wasn't just about money. I think it was more about silencing a powerful institution. All right, fast forward to 1989. The Iron Curtain falls. There was a transition from a socialist regime to a democratic state. And Hungary was facing a monumental challenge. How do we undo 40 years of injustice? So among other things, the country aimed to at least partially rectify the abuses of the dictatorship done to churches. So in 1991, the exact inverse of the nationalization, the restitution process, in Hungarian terminology, it is the property settlement that began. All right, just in a nutshell, let me elaborate first on the restitution of private property in Hungary. We cannot talk about privatization after the transition. The economic situation, the sheer number of the potential claims, and the cost of potential compensation didn't allow the country to provide full restitution or full compensation. The process chiefly pertained to providing partial compensation, and this happened in the form of so-called vouchers. You can see a voucher on this slide. So no restitutio in rem happened in case of private property. Now, churches had a slightly different fate because the enactment of this Act number 32, this is basically the most important law of this period of normalization. So this enabled religious organizations to apply for restitution. So churches could reclaim property. let me clarify what does the church, the term church and its property consist of when it comes to restitution. So by the term church, we also mean all the religious communities and organizations after the transition, and when it comes to immovable property that is subject to restitution, we mean all the buildings and lands that are or were used to communal and also for religious purposes, of course. So in this context, even a property of a foundation was subject to restitution, for example, if it was established for the benefit of the church. All right. Let's see what was the premise of church property restitution. So, as I said, during the regime change, the normalization of church and state relations happened. It was a gradual process. The government recognized, again, the church's role, not only in religion, but also in preserving culture. And the church's influence on society has once again been brought into focus. So the role itself was restored. However, the financial resources were missing or at least limited. So the so-called guiding principle of this act, this Restitution Act, was to create the basic material conditions for functionality and to ensure this way the free exercise of religion, but also to remedy, of course, to a certain extent, the damage that was caused to churches. Regarding the conditions, there were limits, of course. Not all properties were returned. Firstly, restitution was only possible for properties seized after the 1st of January 1984, without any compensation, and pay attention here, only if they were still in state hands. So by the time, of course, when the law entered into force. So the scope of this restitution law does not extend to former ecclesiastical property that had already been sold off to private parties. This was an issue brought before the Constitutional Court, and it examined the fact that the law excludes even monetary compensation, but the court rejected the application on procedural grounds, actually, so the merits weren't examined at all. All right. Secondly, only the properties that were and also would be used for religious or educational, health, social, and so on purposes were eligible. So, for example, if there were some income-generating purposes or when the economic utilization of that property was in focus, that weren't covered actually by the law. So again, we can see that the focus was on this functionality principle that shaped the whole restitution process. As regards the time limit of it, at first the original deadline for completing the restitution was set for the year 2001. This was an ambitious goal, but we know that, as with many legal processes, some things are easier said than done. So in 1997, the complexity of restitution was recognized, and they amended the law, and the deadline for settlement had to be extended to 2011. The implementation of restitution was carefully structured. Actually, there was an annual schedule based on the proposal of so-called conciliation committees. These committees, each church had these committees, and the committees were consisting of both church and state representatives or government representatives. So the government basically adopted lists based on the proposals of the conciliation committees, and the implementation of the settlement was planned to be carried out by following this given schedule. The government also signed compensation agreements. I will elaborate on that in a minute. but it's important to mention that from 2005, churches could sell their claims to the bank as well. Why? This allowed them to receive immediate compensation, and the bank waited actually for the government to pay the claims over time. Now you can see numbers, and let's see the ways of property settlement. I clarified that churches had the unique advantage of reclaiming buildings, so restitution in kind happened. This could be settled either by direct agreement between the owner, for example, the municipality and the church, but this could fail, and the government would decide the matter, for example, when a public institution was occupying and using the building, and in these cases the central budget had to provide compensation for the institution to move into a new place. However, restitution in kind was not always functional, either because the costs of relocating the public institutions occupying the building, or the property had fallen into such disrepair that returning would have been more of a burden than a benefit. So in these situations, one alternative was to provide the church with other state-owned properties or land, or another option was monetary compensation. Another key feature of Hungary's restitution was the introduction of the property annuity. This is a system that came into focus when the legislation, when the building wasn't claimed by the church, or it couldn't be returned, or wasn't settled by monetary compensation or exchange. So in these cases, the church could apply for this annuity, an annual payment funded by the government, and this could be used for religious, educational, and social purposes. Yes. All right. To sum up, by 2011, the process of church property settlement was essentially complete. The law affected 13 churches, and more than 8,000 restitution claims were submitted. However, on one hand, the strict conditions on restitution, such as the requirement that the property still should be in state hands, so this meant that more than 30% of the claims filed were not covered by the law, so a significant number of claims were either withdrawn or rejected. Another problem was the buildings or the properties' bad shape, and of course the present users were not eager to spend on maintenance, knowing that the building would not remain their property. But if we ask ourselves, considering all the circumstances that the restitution process in Hungary can be considered as accomplished or successful or not, I see this, and I think it can be seen as an equitable compromise based on the principle of functionality that guided the process. So churches got back properties or financial compensation to support their work. There was another feature that characterized the settlement, that was its gradual nature. So the opportunity to spread the financial burden with the transfer over time was there, and in this way they tried to prevent new injustices and uncertain legal circumstances. So Hungary opted for a pragmatic approach. It was a balance between past injustices and present needs, I would say. And this early example of restitution was not, of course, flawless and free of mistakes or omissions or losses and conflicts, of course, but we can state that it resulted in a network of truly functional and competitive church institutions in Hungary. Thank you.